Oyez, oyez, oyez. The United States all who have business before this court, bless the United States and its honorable. Please be seated.
Good morning. I'm Chief Judge Allen, and I'm joined by Judge Laurer on my right and Judge Jaquith on my left. We're convened this morning to consider arguments in the matter of Victor B. Skaar versus Douglas A. Collins, Secretary of Veterans Affairs, case number 25-4066. Would counsel, beginning with petitioner's counsel, enter your appearance for the record?
Good morning, Your Honors. Rose Carmen Goldberg of the Veterans Legal Services Clinic at Yale Law School. I am joined by law student intern Grace Parker, who will argue on behalf of petitioner Skaar. I'm also joined by co-counsel supervising attorney Ashley Anderson and law student intern Mikael Tessema.
Welcome, everybody. Good morning.
Ronen Morris for the secretary, and with me is.
Nice to see both of you. And I understand that petitioner's counsel wants to reserve 10 minutes for rebuttal. Is that right? All right, we'll make that happen. And Ms. Parker, you can begin when you're ready.
Good morning, Your Honors, and may it please the court, Grace Parker, law student intern, appearing on behalf of petitioner Victor Skaar and a proposed class of Palomares veterans. Mr. Skaar is 89 years old and faces terminal prostate cancer. He was deployed in 1966 to clean up carcinogenic debris. He's been denied skin cancer benefits for more than 12 years. Today, he is seeking relief for a class of Palomares veterans exposed to radioactive plutonium because the Secretary has ignored them, strategically mooted them, and unlawfully withheld relief. Today, the Secretary argues that Mr. Skaar, an 89-year-old veteran with terminal prostate cancer seeking relief for the veterans he bravely served with, is actually the one at fault for withholding relief from these veterans. A writ is necessary and appropriate here in light of the Cheney factors to protect the court's prospective jurisdiction and to provide relief that has been unlawfully withheld and unreasonably delayed.
So can I stop you there? So I'm having trouble understanding why the writ is necessary here to protect our jurisdiction, prospective jurisdiction over Mr. Skaar's claim.
Your Honor, Mr. Skaar has no adequate alternative means of attaining relief because the relevant relief here is a class certification decision.
So no. So let's assume you had never made a class request, okay? And Mr. Skaar has his claims, right? The world in which we live, you have made a class request. Mr. Skaar still has his claims. Whether or not we intervene at this moment on the class request, the aggregation request, how does that affect the court's prospective ability to adjudicate Mr. Skaar's individual claim?
Your Honor, we're not arguing that the Secretary is inhibiting this court's prospective jurisdiction over Mr. Skaar's individual skin cancer claim, but it is withholding a class certification decision that Mr. Skaar has a right to under the Supreme Court's holdings in Garrity and in Roper.
Well, but they're not withholding anything. The VA, the board, right? The board determined that it didn't have the power to do that. Now, I understand Mr. Skaar disagrees with that determination, number one, and two, thinks that the board should have addressed the merits, right? But saying that you can't act on something isn't withholding a decision, right? For example, if Mr. Skaar filed here a claim for to avoid a tax penalty that the IRS had imposed on him, and I denied that request because I said, we don't have the power to issue that relief. You have to go down the street to see our friends at the tax court. I wouldn't have withheld a ruling on the decision. I would have ruled that I don't have the authority to do it. Maybe I was wrong. Maybe we do have some hidden authority to have this rebate authority. But why would it be withholding?
Your Honor, it's withholding because the board is clearly wrong that it lacks authority to aggregate.
Let's assume that's true. Let's ride that pony the whole way. They haven't withheld anything, right? And so I don't understand how the writ isn't then a substitute for an appeal, right? Because whether or not the VA is right or wrong is immaterial for purposes of whether or not the writ is necessary to preserve our prospective jurisdiction. Do you see what I'm saying? That I'm really having trouble struggling to understand how the what you say is erroneous determination about the class question prevents our jurisdiction or is any way a withholding of action.
Your Honor, the case Harris v. McDonough is helpful here. In that case, the Secretary unlawfully refused to issue a decision on Mr. Harris's request to reopen his case based on new and relevant evidence. Instead, it issued what it considered to be a non-appealable message notifying Mr. Harris that it could not adjudicate his request. Because VA had a duty to make the decision that Mr. Harris asked for, the court ordered it to do so. And it found that the Secretary's recommended alternatives, even though they could have resulted in Mr. Harris getting benefits, they were inadequate because Mr. Harris had a right to the decision he requested.
Yeah, but isn't that, I mean, I as you may or may not know, I had the petition that Mr. Skaar filed before this petition. And I issued an order to the Secretary in which I said, I'm going to grant the petition and order you to decide the motion. So tell me, are you going to decide the motion? And then they came back and they had a declaration from a vice chairman that issued a letter saying the board doesn't have the authority to do that. So they've ruled on it. It's just I understand you don't like it and you want it to be on the merits, but I still don't understand how it affects our potential jurisdiction that there is this what you consider to be erroneous determination that the board lacks the authority to do this. We could review that on direct appeal, couldn't we?
The court held earlier this year that the board's letter denying its authority to aggregate is a non-appealable decision. And so
True. If the board denies Mr. Skaar's claim, he can appeal to the court, and as part of that appeal can raise the aggregation question on direct appeal, right? It may not be an appealable determination, it's an interlocutory determination. But when the merits come before the court, you agree with me that that's folded into the merits. We could reach that as part of the merits determination, right?
yes, Your Honor, this court could review the board's letter denying its authority to aggregate when Mr. Skaar's final skin cancer claim is adjudicated. But that decision will be unreasonably delayed, like in Harris, how because Mr. Harris had a right to the decision he asked for, the Secretary's proposed alternatives would have been unreasonably delaying.
So why, again, maybe I'm missing this. Why is there a delay at all? I understand you want a merits determination on aggregation, but the fact that you didn't get a merits determination, but you got a determination that said no on a reason that you didn't want, doesn't make it a delay, right?
Your Honor, it will be a delay because in order to appeal the board's letter denying its authority to aggregate, Mr. Skaar first needs an RO decision, a final board decision, and the board recognizing its authority to aggregate, which will be unreasonably delaying the class certification decision.
How? It's already been made. See, that's what I don't understand. The claim is moving. VA has denied, I'm saying VA, the board has said, we don't have the authority to do that. They deny it for that reason. So it's not unreasonably delayed. To be sure, the time for which we can rule on that might be delayed, but that's not the agency's delay. that's the result of the fact that this is an interlocutory determination that we have held is not, quote, a decision, right or wrong. We've held that it's not a decision. So I don't understand the delay. What is the agency delay here?
Your Honor, the agency has delayed the class certification decision by not addressing the merits of the class and by denying its authority to aggregate. It did not issue a class certification decision. It denied its authority to aggregate. Mr. Skaar has a right to a class certification decision under the Supreme Court's holdings in Garrity and Roper, and the Federal Circuit.
So your position is those cases, when I go back and read them, say that he has a right to a merits-based determination, even if the motion were denied because the agency believed it didn't have the authority to act.
Those cases provide Mr. Skaar a right to a class certification decision, Your Honor, and the board is wrong that it lacks authority to aggregate.
Okay, so switching gears then, how would it be that your request, you say the third request, which says, if we were to say that the board considered and rejected certification, you ask us to, quote, direct the board to certify the proposed class. How can that be squared with the Federal Circuit's holding in Wolf that says that you can only, a mandamus can, quote, only compel action in the appeal. And then the Federal Circuit went on to say it can't, quote, dictate a particular outcome. Wouldn't it dictate a particular outcome if we ordered the board to certify the class?
No, Your Honor, we're not asking for an outcome. We're asking for a procedural decision. Like in Heller, how this court found Mr. Heller was entitled to advancement on the docket, we are simply asking for a procedural outcome, a procedural decision, not the actual outcome on the dosimetry methodology, Your Honor.
So that's the distinction you're drawing, is that the outcome in Wolf was, I'm going to use the word substantive, right, about whether or not something qualified as reimbursable under the particular statute. And here you're saying that Wolf doesn't extend to the point of a procedural ruling that doesn't rule on the actual merits of the underlying claim.
Yes, Your Honor. Your Honor, the board is wrong that it lacks authority to aggregate, and it has made a clear error, which under the Federal Circuit's holding in Waymo v. Uber Technologies is an abuse of discretion and creates a clear and indisputable right to a writ of mandamus. There's two major reasons why the board does have authority to aggregate like other agencies. First, federal courts have long recognized that Congress generally vests administrative agencies with considerable procedural authority. VA also has this authority under Section 303 to ensure proper execution and administration of all laws and the control, direction, and management of the department, and under 512 to delegate and subdelegate that authority to the board. The Supreme Court has recognized similarly broad statutory authority as providing procedural authority. In FCC v. Pottsville, the Supreme Court concluded that when Congress gave the FCC the authority to grant broadcast licenses as the public convenience, interest, or necessity require, that necessarily meant that the subordinate questions of procedure in ascertaining the public interest were left to the Commission. The Supreme Court later held in FCC v. Schreiber that whether the FCC adopted those procedures through an adjudication or through a rulemaking did not make a difference. The second major reason that the board does have authority to aggregate is under Section 501. Congress clearly did not intend to prevent the board from aggregating when it granted broad statutory authority to prescribe all rules and regulations which are necessary or appropriate to carry out the law, including the manner and form of adjudications and awards. The Federal Circuit in Monk v. Shulkin recognized that this court's similar statutory language meant that Congress did not intend to prevent this court from aggregating. Under Section 7264, the proceedings of the Veterans Court shall be conducted in accordance with such rules of practice and procedure as the court prescribes.
Considering the Federal Circuit's discussion of jurisdiction in Score 2022, why do you think that the board could entertain jurisdiction over claims that have not been filed or still pending before the regional office?
Your Honor, the board's jurisdiction is broader than the court's. It's not limited to final decisions at the RO, and it can make decisions that affect the provision of benefits. Under Section 7104, it can review questions, not just decisions. And the Federal Circuit's holding in Jackson v. Principi indicates that the board is not limited to considering only decisions made by the RO and may consider questions on behalf of the Secretary necessary to the provision of benefits. Your Honor,
Ask a question. You mentioned the Cheney conditions, and of course, one would require the petitioner to prove that there are no adequate alternative means of relief. What are the? Can you think of another alternative means that your argument would be that it would be inadequate? For example, the ability to petition the Secretary to create a rule for the board to aggregate claims or class certification.
Your Honor, the Secretary has made more than clear that its position on aggregation, and so we think that seeking rulemaking on this issue would be futile. Under the Cheney factors, rulemaking is also not an adequate alternative under the Federal Circuit's holding in Beaudet v. McDonough, which said that when a petitioner is seeking judicial review of an adverse decision, rulemaking is not an adequate alternative.
How has the Secretary made that clear? So it sounds like petitioner has not asked the Secretary to create rules under 38 U.S.C. 553E, which clearly petitioner would have a right to request that. So how has the Secretary made clear that he is unwilling to make rules regarding aggregation?
The Secretary acts through the board, Your Honor, so we view the board's letter as making that abundantly clear.
Have you considered then appealing that decision to the Federal Circuit?
Appealing the...
If the Secretary refuses to make a rule regarding aggregation, and you're stating that the board's letter from July 2024 is a refusal on behalf of the agency to make rules regarding aggregation, would the petitioner then not have the ability to appeal that decision to the Federal Circuit under existing statutes?
That may be true, Your Honor, but rulemaking is not an adequate alternative under the Cheney factors and under the Federal Circuit's holding in Beaudet v. McDonough. If the court, if petitioners should seek rulemaking instead of a petition for extraordinary relief, the court would always be able to find that a mandamus is not appropriate because there's another alternative. The main alternative that the Secretary argues here is that Mr. Skaar should wait for a final board decision and then appeal the board's letter denying its authority to aggregate. The problem is the history of Mr. Skaar's skin cancer claim indicates that the board is willing and able to withhold that final decision. The board has remanded his skin cancer claim twice, even though there's nothing further he can provide to the RO. He's been in remission for skin cancer since...
But this is going back to my first question, right? So you're not, though, I mean, are you asserting that the board is unreasonably delaying the adjudication of Mr. Skaar's individual claim?
Your Honor, we're arguing that the unreasonable delay is as to the class certification decision, and because the proposed alternative requires first a final board decision on Mr. Skaar's skin cancer claim, that is part of the unreasonable delay.
I'm not being mean or not trying to be, all right, but I need like a direct answer here. Are you claiming that VA is unreasonably delaying the adjudication of Mr. Skaar's individual skin cancer claim?
Yes, Your Honor.
Because of what you consider to be the class action denial,
Part of the
or because of the remands?
Part of the unreasonable delay, Your Honor, is as to the repeated and unnecessary remands. Given that Mr. Skaar has been in remission for skin cancer throughout these proceedings and can provide nothing more to the RO.
So as to that, let's just take that as a claim. The whether or not there was aggregation doesn't matter at all, does it? I mean, you could be able to say what you just said to me, whether or not you had ever made a motion for aggregation or not.
Yes, Your Honor, but we are seeking a class certification decision today, and that is the unreasonable delay the Secretary is causing.
And so I'm going to go back and read your petition again, but is it your position here, and you can think about this, is it your position that you have asserted unreasonable delay in the processing of the individual claim in your petition?
Your Honor, the unreasonable delay is as to the class certification decision, and so to the extent that the delay in his individual skin cancer claim contributes to that, but is not all of that, that is the unreasonable delay. But we are not alleging that the individual skin cancer claim alone is being unreasonably delayed.
And so, and you're going to go over time, but I'm going to add some time. Because I really, really, really want to understand this. I'm struggling to understand what the class claim adds to it. So, I mean, imagine a world in which the board has remanded the 2 times that you talked about, okay? And there is no request for aggregation. And then the world in which the board has remanded the 2 times, there is a request for class or aggregation that the board has said we don't have authority to do. I'm trying to understand what the addition of the class issue has anything to do with any sort of delay. I can't understand that.
Your Honor, the issue is that Mr. Skaar is entitled to a class certification decision, and that by making a clear legal error, the board has denied that class certification decision.
And does that denial have anything in it? Does that denial have anything to do with adding delay?
Yes, Your Honor, because the alternative that the Secretary proposes requires Mr. Skaar first to get an RO decision, a final board decision, and for the board to recognize its authority to aggregate.
Yes, but leave aside the aggregation. I mean, that's bootstrapping in my mind. Mr. Skaar has a right to have his skin cancer claim adjudicated. It now looks like you're saying that is not being delayed or unreasonably withheld. And you're saying he has a right to have a class certification decision. But he's gotten a class certification decision. The board said we can't do it, right? And so I guess I'm just struggling to see how there's any delay because the board has already done what you asked it to do, although be it not in the way you want it to do it. It didn't rule on the merits. It said we don't have the power to do it. I don't understand how that delays Mr. Skaar's claim.
Your Honor, it is unreasonably delaying the class certification decision because the board is clearly wrong that it lacks authority to aggregate. And that withholds the class certification decision that Mr. Skaar is entitled to. The board did not make a class certification decision in its letter denying its authority to aggregate. The board's letter begins and ends with discussion of how it lacks authority to aggregate and how aggregation would be inconsistent with the board's regulations.
How is that not the equivalent of denying the request for aggregation? I mean, if I say I can't do it, that might be wrong. It might be wrong 10 ways to Sunday. But I'm just struggling to see how that being wrong makes it not a decision or not. We've held it's not a decision for terms of appeal, but what I mean is colloquial, a decision, a determination.
Yes, Your Honor. A class certification decision would address the merits of the proposed class and provide these Palomares veterans an additional alternative opportunity to propose another class addressing any deficiencies that the board might have addressed with respect to this particular class. The board did not do that. Instead, it unlawfully ignored its authority to aggregate and withheld a class certification decision. If it were to make a class certification decision, it would be required to provide sufficient reasoning. but the board did not address this proposed class.
But it did provide reasoning for the decision that it gave, didn't it?
Yes, Your Honor.
Correct or incorrect, but there was reasoning spelled out, right?
Yes.
And if that's the measure of the delay, then we're at 16 months now. Is that the measure of the delay that the veteran asserts is unreasonable?
In addition to the delay required by the Secretary's proposed alternative, which is waiting for an RO decision, a final board decision, and the board recognizing its authority to aggregate in order to get a class certification decision, Your Honor.
What is the common class question that is spurred the class certification request?
The common class question is whether the U.S. Air Force dose methodology is sound scientific evidence. This court held that the board had never addressed that question since it received the U.S. Air Force dose methodology in 2013. And even when this court ordered the board to provide relief by addressing the U.S. Air Force dose methodology, the board instead ignored that remand order and then only remanded Mr. Skaar's individual skin cancer claim.
What's the connection there? The veteran has argued, as I understand it, that the only way to get the class certification to get the dose estimate methodology reviewed is through certification of a class. Is that still the veteran's position? And if so, why?
The board has refused to address the dose methodology, and aggregation is one way to continue to bring this in front of the board in order to get it to do so. It's not clear if the board will ever do so, especially in face of this court's order, which it ignored.
But you too can bring that, if it's true, if the board flouted the order in, didn't ensure substantial compliance with remand, with our remand, that's an appealable issue, right? If it goes back to the board and the board denies the claim, you can come here and you can say that the board didn't substantially comply with the remand, right?
Your Honor, the relevant relief that we're asking for today is a class certification decision. The benefits of aggregation stand on their own, independent of whether the board addresses the dose methodology.
So now, okay, so is the fact that the board didn't, in your view, address the dose methodology relevant or not relevant to what we're talking about today?
It's relevant in that the board has refused to provide relief to the Palomares veterans, and aggregation is a tool that can help them bring the issue in front of the board.
Has petitioner asked the board to get a decision from the General Counsel of VA regarding the dose methodology?
Has petitioner
Requested that the board get a decision from the General Counsel. As you know, the General Counsel's opinions are binding on the board. So an option would be to ask, and that's what's underlying all of this, right? The dose methodology that the Air Force used. Is it not an option for petitioner to ask the board to get an opinion from the General Counsel, which would be binding across the board for claimants regarding the dose methodology?
Potentially, Your Honors, but the relevant relief is a class certification decision. That is what Mr. Skaar is entitled to, and the benefits of that stand on their own, independent of the dose methodology. And so what we're seeking here today is a class certification decision, and that is what the board has withheld.
Okay, so the answer is no, the petitioner has not sought from the board the General Counsel opinion.
No, Your Honor.
One more question. Let's say for the sake of discussion that the VA agreed that they did have all the authority they needed to aggregate or certify a class. Would that be discretionary, as the Secretary's Counsel has argued in the briefing, or do you view it differently? In other words, in order for the court to issue a writ here, it would have to be something that was not discretionary. And so what's the petitioner's position on whether or not that would be discretionary?
Whether the board can aggregate is not discretionary in this case because the board is required to issue a just and speedy decision, which it has not done, and which is particularly important. Aggregation is particularly important here given the advanced age and illnesses of the Palomares veterans and their inability to otherwise adequately challenge the dose methodology. Whether aggregation is discretionary or not is not actually what the board letter says. It says that it lacks authority to aggregate. Discretion presupposes that authority. And so if the board found that it lacked, that aggregation was discretionary, it would have needed to say that in the letter, and it did not. And it
That's
committed.
my hypothetical. I mean, the question I asked you was the hypothetical on if the agency agreed that it had the ability to do so. Would it be discretionary? In other words, is it a procedure under complex litigation procedures that are available? And if so, would it remain discretionary or obligatory? So it sounds like the argument is based on the timing that it would not be. If I understand your response, it's that based on the factors here, it goes back to the unreasonable delay. Is that the argument?
Aggregation is also necessary here, Your Honor, in order to adequately challenge the dose methodology. Aggregation allows these veterans to pool resources, and the dosimetry methodology is an issue of complex scientific and medical issue, which individual veterans are poorly situated to challenge on their own. By pooling resources, the veterans would be able to come to a more accurate decision and to more adequately challenge the dose methodology, which they are unable to do right now. The burden currently lies on individual veterans, their access to experts, their access to physicians who are capable of overcoming a dosimetry methodology that the board will not even stand behind. So aggregation is necessary in order to adequately challenge the dose methodology, and also necessary here, like you said, because of the unreasonable delay.
So you're not saying that you're representing Mr. Skaar, right? And is your position that you cannot adequately challenge the radiation assessment from the Air Force unless the claim is aggregated?
No, Your Honor.
So you can, right?
Our position is that Mr. Skaar is entitled to a class certification decision and that the class members are not able to adequately challenge the dose methodology.
So, but I'm asking you about Mr. Skaar. Is Mr. Skaar adequately able to challenge the dose methodology?
Yes, Your Honor. This court has previously.
So what harm to him is there, even if you're right that other class members would need this, if Mr. Skaar is going to be leading the charge?
Mr. Skaar doesn't need an economic harm to him in order to be entitled to a class certification decision. It is a legal harm because he's entitled to a class certification decision.
But he is totally able to challenge the dose methodology with the assistance of your clinic.
Yes, Your Honor. This court has previously held that Mr. Skaar is adequate to challenge the dose methodology on behalf of a class of Palomares veterans.
But on his own behalf is what I'm asking for. You can challenge the dose methodology, which I am assuming you have been doing as part of this appeal, right?
Yes, Your Honor. He can do it on behalf of himself and the class.
Right, but he can do it on his own, whether there's a class or not, right?
Yes.
Okay. Thank you. Go ahead.
And you've given a numeric estimate of the number of veterans who were subjected to radiation exposure, but are there other veterans who there are no other named class members? Is that right?
Your Honor. We estimate that there are at least 100 veterans who would benefit from the dose methodology, but under this court's classification rules, the Secretary has the burden of disproving numerosity.
All right, we're going to give you your full amount of rebuttal. We've taken you over with our questions. Thank you. Mr. Morris? If you need it, you have extra time, as much as you want. I'm feeling generous this morning now that we're being paid, so all of us in the courtroom. So feel free to start.
Thank you, Your Honors. May it please the court. Your Honors, there's no threat to this court's jurisdiction that would justify exercising authority under the all writs act. The extraordinary relief that petitioner demands would be inconsistent with the proper exercise of any such authority. And the conditions for the issuance of that extraordinary relief are nevertheless not met. If petitioner wants to press this class action argument, petitioner can do so using the statutory appeals Congress that Congress put in place. What petitioner cannot do is use the All Writs Act to override or circumvent that process. Your Honor, before jumping into this, I would actually like to remark about one of the points that the petitioner made, which is the idea that there might have been some delay in the underlying skin claim. Well, I do believe that petitioner also conceded that there was not. Petitioner indicated that there had been several board remands that are essentially frivolous because no benefit can come of that. I'd note, though, that most recently, petitioner, when the agency issued a decision, petitioner specifically chose higher level review rather than board review. And in that higher level review, petitioner specifically advocated for a remand back to the agency to correct a duty to assist error. So the idea that the board did something that petitioner could not possibly stand to benefit from is inconsistent with petitioner's own litigation strategy at the agency.
And can you, I meant to ask this of Petitioner's Counsel, but where does it stand now? Where does it, meaning the claim, the skin cancer claim, where does it stand now?
My understanding is that it was most recently sent back by the higher level reviewer back to the agency to provide the examinations that the board had previously requested. I believe that there was some discrepancy into the schedule.
And so, as far as you know, it's still pending before the agency of original jurisdiction.
That is
Following the favorable HLR decision.
That's correct. On the basis that the petitioner.
Does that address, or will it address, the dose estimate methodology, or is this entirely based on the confusion or whatever it was over whether the veteran was a no-show for an examination?
It's to provide, the basis of the remand was to provide I believe to provide those opinions that the board had ordered or the examinations. I don't think there's any limit to what petitioner can argue to the agency. And again, while I don't think that this is actually relevant to this particular case, just to clarify some of those underlying points, the idea of there being a prolonged period of time to get to a board decision, a final board decision, Your Honor, a lot of that is based on the choices that petitioner himself is making in this case, and this petitioner who chose specifically to seek higher level review, not a board decision. So again, any idea of there being secretary created delays in there being an ability to challenge the board's ruling on the class action is in large part a product of both the system itself and the choices that petitioner has made with the system.
There have been board remands, though, haven't there? I mean,
I believe there were two board remands. The first board remand was for the issuance of in part for the issuance of a statement of the case, so that matter this skin cancer claim could be properly appealed to the board, and the second for the provision of medical examination.
And do you have a position, again, it may not be relevant at all for the issue we're talking about today, but anything about this notion of the board not complying with a remand in terms of our remand, in terms of addressing the dose methodology situation?
Your Honor, I'm not fully prepared to answer that, but given that the board remanded the claims for certain process and duty to assist, addressing that substantive issue seems to have yet been required. It presumably will do so in its ultimate final decision should the appellant choose to pursue a board appeal.
And assuming that happened, I assume that, so assuming there's a denial, the AOJ, and it comes to the board, your position is that, and assume the board didn't address the dose, your position is that appellant or the petitioner here would be able to assert that as an error, whether it was an error or not, but they could assert it as an error on a direct appeal to us?
The failure to address
Failure to comply with our prior remand.
Yes, with the exception of any implicated factors such as waiver or abandonment of issues or challenges, it would be a matter that the appellant might press. Again, a lot of that is determined based on the appellant's actions.
But my point is, there's nothing that would categorically bar this. That's part and parcel of the whole thing. Even if the board remands several times, if it continues to ignore it, and I'm just assuming it is.
Right.
And that is bound up in the ability to then raise that issue on appeal.
Yes, it is a part of the administrative record, and it is a matter that can be challenged.
And do you also concede that if the board assume it comes back up to the board, and then the board denies the claim for whatever reason, and then the the petitioner files an appeal with the court, do you agree that the issues about the appropriateness of the board's determination that it lacks the authority to aggregate claims, that too would be part and parcel of the issues on appeal?
The short answer to that is yes, but just with the brief clarification, though, the motion and the ruling are both a part of the administrative record, but again, secretary can't control petitioner's actions. So barring any actions that would be seen as a waiver or abandonment of those issues, then yes, the challenge would be preserved at that time.
What is the secretary's view on the board's July 2024 denial of the motion to aggregate? Does the secretary consider that a refusal to engage in rulemaking under 38 USC section 553?
No.
E?
No. The motion filed at the board. There's no petition for rulemaking. The motion itself. If I may, though, go back to what was, first point here, which I know was discussed in counsel. There is no threat to the court's jurisdiction here. There is no basis for this court to exercise jurisdiction in this case. And the petitioner's skin cancer claim is pending. Adjudication of that claim has not been obstructed in any way or any part by the secretary, and it's proceeding in line with the adjudicatory process and the choices made by Mr. Skaar.
But it's at 11 years now, isn't it? Isn't that right? Wasn't it filed in 2014?
I believe it was 2013 or 2014. It was found to have been reasonably raised. But, Your Honor, the time since filing is not the operative facts here. As the Secretary noted, a large part of that time, about 7 years, was spent in litigation in the courts over the propriety of the class action that the petitioner brought certified class action. The claim itself has otherwise been proceeding expeditiously through the system. When the matter was ultimately remanded back to the board remanded it for the issuance of a statement of the case, which was promptly issued. An appeal was made. The board remanded for a medical opinion. An agency decision was issued. The appellant saw a higher level review. The higher level review decision was made. The appellant had argued for remand back to the agency. That's where we are now. So there's been no obstruction or delay. And again, the system has played out the way it was designed to. And in large part, the timeline here has been shaped by the petitioner and the petitioner's own choices. It's not blaming the petitioner for anything, but this is simply noting that In the writ context, the threat to the court's jurisdiction or delay has to be caused by the secretary or by the government. And in this case, there's been no showing or truly in the petition at least, allegation of any government doings that have delayed any aspect of the veteran's feelings or claim. And to the extent that the petitioner rather has alleged this idea of delay in the adjudication of the merits of the class action motion, I'd first note again, Your Honor, that a ruling was made. That was a substantive ruling that denied the request for aggregation. So that action has been taken. But I'd also note, Your Honor, that contrary to the petitioner's characterization, the board did specifically address even more so than just the authority question, stating, even assuming the secretary has the authority to aggregate, the board's jurisdiction is limited to appellate review of initial adjudications by the secretary. So the board did go even beyond the idea of authority. There's no question here that it addressed the substance and denied the motion. That's all that was required. So there's no delay in an action.
That's still an authority question, what the board has jurisdiction to do.
It related to the class that was proposed, the proposed class, including veterans who had not yet received agency decisions, who had not necessarily filed claims. So it pertained to the underlying, call them, merits of certifying the proposed class. Assuming the board could, it still couldn't because the proposed class is inconsistent with the board's jurisdictional limitations and statutes that govern it. But, Your Honor, the issue is that the board ruled dispositively on the motion. So there can't be any delay related to action taken on the motion. So there being no delay anywhere in this case, and there being no other threat to this court's jurisdiction, again, it has none to act in this case. Understandably, appellant wants to litigate the merits of the underlying position that the board has this authority to aggregate cases, and here's how it can do that. But writ is not the context to make that argument. The appellant.
I discussed this with petitioner's counsel too, and it is something that I noticed in the case when dealing with it. So it's the point from Wolf about cannot dictate a particular outcome. That's what the phrase was. And so I too thought, okay, did the Federal Circuit mean a particular outcome, meaning the grant or denial of a particular benefit? In that case, the reimbursements, or did it go beyond that? And I'm not aware of any case that actually has applied that concept beyond the granting the ultimate relief you seek. I just am curious about the Secretary's position about that. Are you following that horrible question?
I understand the question. I will say not actually prepared for the answer that was given earlier, and I do think that's a valid question. I think in this particular case, though, that there's no question that what's being sought is a specific outcome determinative decision, because again, the board made a specific ruling, and what the appellant, what the petitioner is asking for is essentially overruling that and inserting essentially different language in that rule. I think that can be distinguished from the case cited by the petitioner and the idea of ordering a relief that is otherwise specified by statute as something that is required to be given. This, again, is simply asking that the board's analysis be changed and the outcome, the relief that it denied, that ruling be changed to provide a grant.
And we could avoid that question, in your view. We could say even if Wolf's language didn't extend, there would be other bases, as I understand your argument for.
Yes, Your Honor. The threshold requirement is the threat to the court's jurisdiction, which is not present. The second requirement is whether the relief can be provided. Our position is no, but even if the court were to ignore that or answer otherwise, the three conditions for the issuance of a writ still need to be met, and none of those are met in this case. So any any of those reasons is sufficient to deny the petition, although the first should be the basis, because that's a jurisdictional issue. There's no basis, there's no justification for getting into the conditions for the issuance of the writ. Again, the appellant has an appeals process as well, which is one of the conditions. And shown that it's inadequate under the circumstances, the matter can be litigated for this court on when a final decision on the skin cancer claim is issued, and much of that is determined based on the appellant's choice of actions in the underlying process.
What about the Secretary's argument in January that rather than an appeal of the July 2024 board decision letter regarding its authority, a petition was the viable option? It was the language that was used.
I don't believe that our position was that it was viable in the sense that there was merit to it, but in the sense that if one is trying to otherwise appeal an interlocutory issue that cannot be appealed, a writ would be the only possible avenue to do that, provided that the threshold requirements of a threat to the court's jurisdiction is met, and provided that the conditions for the issuance of a writ are met. Because the writ would, in the extraordinary circumstances where all of those requirements and conditions are met, be the path towards reviewing an interlocutory order, as the court did, I think, Heller and Wiggins concerning advancement on the docket. Those circumstances. So again, our view is not that it's viable in the sense that there's merit to it, only that it would be the only potential recourse. Again, the avenue for relief in this case is the process that Congress put in place. Congress specifically chose to funnel procedural substantive disputes through final decisions. Congress was aware that there would be some errors in the underlying thing. All of those would be addressed in a final decision.
I understand the Secretary's primary argument, which is there's no threat to the court's jurisdiction here, but I want to ask you the same question that I asked Ms. Parker about the ability, if what really is at the heart of this is that those methodology that the Air Force used. What is the Secretary's position about the ability to get an opinion under the Secretary's regulations from the General Counsel regarding the legality or other that would be binding on the board going forward?
My position is that the petitioner would at least have to seek something of that nature before the Secretary could respond to whether the request is.
So the petitioner could ask the board to get an opinion from the General Counsel under Rule 20.804 on that legal question.
To be clear, I don't know the answer to the specific question as to whether the board would be required to do that. But what I do know is...
Well, you're familiar with the rule, right? The rule which says that the board can obtain a legal opinion from the General Counsel, which would be binding on the board.
I am generally familiar with it. I apologize. I did not consider it in the context of this writ because it wasn't something that was raised, and it's not something that I believe is necessarily legally relevant here. But I do, at the very least, Your Honor, while I am unable to answer the question as to whether the board would be required to request that opinion or whether the General Counsel would be required to provide it, at a minimum, it requires that the request be made. That request hasn't been made. Petitioner can request or move the board for anything truly, and the board will respond to that. So I don't know what the outcome would be, but I do know that it appears to be something that petitioner can do. But
would you agree that those methodology is really what's at the heart of this class action request aggregation?
I believe it lays at the heart of the desired class action, and that it's at the heart of what would be asserted to be the common question. Whether it's at the heart of this claim, I'm not entirely sure, because again, there seems to be a desire on the petitioner's part to obtain a medical opinion. And in fact, in these cases, it may very well be that the easiest way to secure grant of benefits is based on the individual facts and circumstances of the case, irrespective of the specific dose estimates. What I can further say, though, here is that to the extent that that is the issue, that is precisely the type of issue that this court can address in an appeal of a final board decision. In fact, Your Honor, to the extent that the petitioner has noted there's no other options, no way, Congress did actually provide an avenue to expedite treatments, the resolution of these claims in 7107B. If the case involves an interpretation of law of general application affecting other claims that can be advanced on the docket, that indicates that what Congress intended was for these types of issues to be funneled through the same system, although potentially expedited for resolution by this court. The extent that the appellant might first want to seek resolution or provide new arguments or different arguments to the agency or to the board about these dose estimates, that's appellant's prerogative. But provided that a challenge is raised, and it appears that one was raised in the past, this is a matter that will be brought to the courts in due course under the system that Congress designed.
Doesn't that same section, the 7107B section, refute the Secretary's argument that the requirement that cases be handled in docket order is an impediment, a showstopper to class actions?
No, the specifically crafted exceptions to the rule are that was Congress's choice. That was Congress's policy choice. Congress created a standard default rule, which is to decide cases in docket order, and it provided certain exceptions and some deference to the Secretary there. But Congress specifically chose to craft that, and in this particular case, Congress crafted an exception that is geared towards expediting issues ultimately to this court through a final board decision that involve legal questions of broad applicability. And again, the petitioner here can very much seek to get that question to the court through the choice of review options. Another petitioner, a putative class member could do the same by raising the challenge, by securing a final board decision and raising the challenge to this court. But in no way is a court's ability to address that issue, the dose estimate question, threatened by any action on the part of the Secretary. And there's no way is waiting for the statutory appeals process for the system to play out in any way, causing any impediment to the processing of the petitioner claim or any other putative class claim. It is simply the process that Congress designed, and that's the process that petitioner is intended to take. To the extent the petitioner argues, nevertheless, that there is that the board clearly erred in this question of authority, petitioner has not shown that there is any clear and indisputable duty on the part of the board to certify classes or right on the part of a claimant to have a class certified. At best, a debatable position, one that can be argued on the merits in due course if petitioner. Your Honor, if there are no further questions, I covered more than you wanted to hear.
No, thank you, Judge. Thank you, Mr. Moore.
Thank you, Your Honor.
Ms. Parker, you have your full rebuttal time.
Your Honor, so I'd like to address 3 points that the Secretary argues today. First, the Secretary is withholding the question of whether the board can aggregate, and it does not concede that the court will ever be able to review that question. Second, aggregation is clearly consistent with the board's case management procedures, including advancement on the docket. And third, the Secretary's briefs do fault Mr. Skaar for the delay in this case, but no amount of faulting Mr. Skaar for pursuing class certification can erase the board's repeated remands, ignoring Mr. Skaar's motion for aggregation the first time, and denying its authority to aggregate, withholding the class certification.
So again, why is it withholding the class action decision when it says what it said in the letter?
Your Honor, it did not make a class certification decision because it did not address the merits of the proposed class. That's particularly true when you consider that the board could have narrowed the class, as this court has done when
So you're familiar with our, I'm sure you are, the saga of Monk, Mr. Monk, right? Which I think your clinic represented Mr. Monk. So originally, one of our now senior colleagues, Judge Hagel, in responding to the class action request made by Mr. Monk, denied the motion because Judge Hagel determined that the court lacked the authority to certify classes. And then that was appealed to the Federal Circuit, leading eventually to the decision in Monk that says that we do have that authority, right? There's no way anybody would ever say that what Judge Hagel did was not a decision, right?
we argue that that would not have been a decision if it were what the board said in its letter.
I'm talking about Judge Hagel. Was Judge Hagel saying the court lacks the authority to certify classes a decision?
I haven't read that decision in its entirety, Your Honor.
Okay, go on.
The Secretary does not argue that the court will ever be able to consider the question of whether the board can aggregate. If the Secretary were to grant at the RO level or at the board Mr. Skaar's skin cancer claim, then the issue of whether the board can aggregate will never be before this court. The Federal Circuit held in Monk v. Shulkin that Mr. Monk was still entitled to a class certification decision, even though between filing for class certification and when the Federal Circuit reviewed that case, Mr. Monk had been granted a 100% disability rating. But he was still entitled to the class certification decision. And that was true even though this court had not adopted a Rule 23 or its equivalent. It found that the question...
Well, but that was a picking off question, right? That once somebody has filed a class action request, as a general matter, the party opposing the class can't pick them off by giving them 100 cents on the dollar, right? I mean, that's what that stands for in Monk, right?
Yes, Your Honor, the Federal Circuit held that the question of whether this court could aggregate was a question capable of repetition, but evading review, and especially in light of the Secretary's history of mooting petitions before judicial review. It noted that if the Secretary could simply grant Mr. Monk's claim in its entirety and get rid of the question of whether the court could aggregate, then that question was capable of repetition but evading review, like the board's authority to aggregate here.
They certainly haven't picked Mr. Skaar off, though, right? I mean, he's still fighting for his skin cancer claim.
Mr. Skaar's leukopenia claim was granted on the grounds of the evidence that his physicians were able to provide, never addressing the dosimetry methodology. And so we expect that the Secretary would love to use that strategy for Mr. Skaar's skin cancer claim as well.
What possible good faith basis do you have to say what you just said?
Your Honor,
That they really want to do what they haven't done? You just complained to us about the fact that they keep remanding it and not granting it. But now you say what they really want to do is grant it? What basis do you have to say that?
Your Honor, this court has recognized the Secretary's history of mooting claims before judicial review.
What basis do you have to tell us that what VA wants to do is get rid of the claim with respect to Mr. Skaar to evade our review of a legal question, given the facts that we have here? You have to be very careful when you throw things around like that. So what basis do you have that they actually want to grant the skin cancer claim to thwart our review?
Your Honor, the basis is simply that the board is trying to withhold the question of aggregation.
You mentioned aggregation. The claim, the skin cancer claim. What basis do you have? And by the way, wouldn't you welcome, on behalf of Mr. Skaar, granting his claim? I'm assuming that's what you want.
Your Honor, the basis is simply that the Secretary has a documented history of trying to moot off plaintiffs before judicial review. The relevant relief here is a class certification decision. Mr. Skaar is not seeking a grant of only his individual claim. He is seeking a resolution of the common legal question for the entire class. The Secretary argues that Congress intended this court to wait for a final board decision before reviewing, but the Secretary does not concede that the question of aggregation will ever be reviewable by this court because it can grant Mr. Skaar at the RO level and at the board level, preventing the court. The second issue I'd like to respond to, Your Honors, is that aggregation is clearly consistent with the board's case management procedures, despite the Secretary's argument. Aggregation is consistent with advancement on the docket because cases can be advanced on the docket if they address an interpretation of law of general application affecting other claims. Aggregation clearly does that by addressing a common legal question. Aggregation is also consistent with the board's duty to decide on a non-precedential basis. Aggregation is not precedential because it only addresses class members. It is not binding on people who have not filed a claim at the AOJ yet. This court recognized the inherent differences between a precedential decision and aggregation in Skaar v. Wilkie in 2019, when it held that class certification would be reserved for cases in which it was a superior vehicle to a precedential decision.
Just out of curiosity, has your client sought advancement under 7107B on the basis of the common question angle as opposed to Mr. Skaar's age? He may have been advanced on the board's docket for that reason.
Mr. Skaar has been consistently advanced on the docket, Your Honor, and this case has still been delayed unreasonably because the board has withheld the class certification decision and repeatedly repeated the case, Your Honor. Aggregation is consistent with docket order because it only necessarily resolves the common legal question, leaving the individualized fact-based adjudications in docket order. The board could also adopt a separate docket for aggregated cases if it desired. It currently has at least 2 dockets, one for cases that have a hearing and one for cases that do not have a hearing, such that cases without a hearing are not held up by those that do need a hearing. So aggregation is consistent with docket order, Your Honors. The third point I'd like to address is that the Secretary does fault Mr. Skaar in his briefs for the delay caused by pursuing class certification. But no amount of faulting Mr. Skaar can erase the board's repeated remands, even though there's nothing further that he can provide, and withholding the class certification decision, meaning that by waiting for an RO decision and a final board decision, if one ever comes, and the board recognizing its authority to aggregate, Mr. Skaar's class certification decision will be unreasonably delayed. The board's refusal to make a final decision as to aggregating this proposed class has obstructed this court's jurisdiction and unlawfully withheld relief. Instead of resolving Mr. Skaar's skin cancer claim, the Secretary faults Mr. Skaar, an 89-year-old veteran facing terminal prostate cancer, who's seeking relief for the veterans he bravely served with. The court's decision today is determinative of whether the Palomares veterans will get that relief.
No, thank you.
Thank you, Mr.
Thank you, Your Honor.
Thank both parties for the argument. I want to thank both parties for their flexibility in terms of the fact that we would have been in Missouri doing this at this very moment, but now we're here. So I do appreciate that the court does. And so the matter is now submitted, and we'll come down and greet counsel.
All right.